big High Court case there involving John Magnier's dispute over the purchase of a 751-acre Barne estate in Clonmel and Tipperary was supposed to get off the ground yesterday but didn't. Discovery issues have delayed the opening and it's been put back to today, Friday. The billionaire businessman John Magnier wants to enforce what he says was a purported deal for the sale of the property to him. This reporting now is from the Irish Times. Fiachra Gallagher is the reporter. Lawyers for John Magnier accused the other side of egregious deficiencies in the pre-trial discovery process. This is a standard process which is part of any civil trial. Counsel for John Magnier said that specific deficiencies in terms of the defendant's discovery of documents had emerged, including questions around their compliance with discovery requests. This included a failure to search an email inbox of Richard Thompson Moore. His family have owned the County Tipperary estate since the 17th century, and also an incorrect claim of privilege over certain documents, Magnier's senior counsel said. Martin Hayden, senior counsel for the defendants, pushed back against any suggestion that the discovery orders were not complied with. However, he did say that he would look at it. However, Martin Hayden said that he was unhappy with elements of the discovery process, and he specifically referred to the failure to search Mr. Thompson Moore's inbox, and he said that he was willing to review the discovery process. Magnier is, along with his children, wants to enforce what he says was a deal to buy this 751-acre farm outside Clonmel for €15 million. He says that the deal was struck in August 2023 at a meeting at Magnier's Coolmore Stud. The defendants in the case are Barne Estate Limited, Mr. Thompson Moore and associated Jersey registered companies. They denied that there was any agreement, and they then subsequently sold the farm to a construction magnate, Maurice Regan, for €22.5 million. Magnier had the deal done for $15 million, he claims. In an affidavit filed on Wednesday by the defendant's solicitors, they suggested that only records of communications contained in phone messages and emails were disclosed to them during the discovery process. And there was concern that other records, for example, typed or handwritten notes that should have been disclosed under their discovery requests were not disclosed. And the second issue that rose yesterday was confirmation by the defendants that an email address used by Mr. Thompson Moore was not searched or extracted from during the discovery process. A letter sent by the defendants' solicitors on Wednesday said the inbox was not searched by a legal services firm that were employed in the discovery process. This letter sent by the defendants' solicitors expressed regret for the shortcoming and said that the firm was unaware until yesterday that the inbox had not been searched. So you would imagine that this inbox of Mr. Thompson Moore would have been certainly significant and certainly well worth searching. Miss Gagan for Magnier's side said it was difficult to understand how such a serious deficiency could have occurred. She said that the most serious discovery issue related to a document of 60-odd pages of typed notes written by John Stokes, the Tipperary-based estate agent, received by the plaintiff's side on Wednesday. Counsel for Magnier said that the Microsoft Word document contained a series of entries on different dates where Mr. Stokes makes notes of conversations with various people, messages and meetings, including the August 2023 meeting at Coolmore Stud when the sale was allegedly agreed, according to John Magnier's side. She said that counsel for Magnier said that privilege was incorrectly claimed over this document and that any competent person who looked at the notes could not possibly take the view that it was appropriate to mark them as fully privileged. In other words, that they didn't have to be handed over or disclosed. She said that they should have been discovered long ago. So this dispute has caused the delay to the trial between the parties. She said that a document of this nature, which she claimed contains many references adverse to the defendant's interests, was not discovered, reflected a fundamental error in approach to privilege. Mr. Hayden, Martin Hayden, senior counsel for the defendant, said that he was willing to conduct an entire review of the discovery process and that he was also unhappy with elements of it, referencing the failure to search Mr. Thompson Moore's inbox. He said that the plaintiff's lawyers were attempting to portray his clients as seeking to deliberately conceal information or not furnish documents. He said nothing could be further from the truth. He also pushed back on the assertion by Ms. Gagan for Magnier's side that his side had not complied with the plaintiff's discovery orders. He said the discovery requests, which were subject to negotiation, specifically sought communications. Mr. Hayden said that for reasons unclear to me, they chose the wording, they chose "I'm being pilloried here today" for complying with what I say they look for. So he's blaming Magnier's side for actually choosing the wording which failed to disclose all the documents that they were looking for because they only look for, quote, communications. In the case of Mr. Stokes' document, he said that it amounted to a rolling diary of events and not a record of communication and therefore wasn't discoverable. He said the document supported the defendant's case, disputing Ms. Gagan's view. Ms. Gagan is senior counsel for John Magnier's side. The case has been adjourned to today, Friday, so we'll see does it get off the ground today. Hope you find the video useful. If you do, hit the thumbs up down below. Thanks very much.